Hi, my name is Marcus Johnston. I'm the solicitor in charge of PCD Solicitors. This is a short video just to discuss one or two important aspects of evidence to consider with historic sexual offences. I'm just driving back from a police station interview that I attended with a client of ours who'd been accused of serious sexual offences going back around about 10 or 12 years. It's a type of case I've dealt with many times in many different areas around the country. And first of all, the police, in the disclosure that's provided to me, referred to the complainant as the victim. And you often see that. You often see the police referring to the victim. But it does beg the question as to what happens if the so-called victim has not actually been assaulted at all. What happens if it's a made-up allegation? Well, in that case, the victim wouldn't actually be the victim. The person who's been accused would in fact be the victim, because that person has been accused of doing something which is a false allegation. So surely the person accused is then the victim. But leaving that to one side, it begs the question as to why people would make an allegation. Now, generally, there are three main types, and sometimes perhaps this is oversimplification, but it's something I go through with clients. You can have a complainant, somebody who makes a complaint to the police, who has genuinely been assaulted by my client, let's say. So if, let's say, you're facing an investigation at the moment, the person making the complaint might complain to the police that you've assaulted them because you have in fact assaulted them. However, there's a second type, and that's somebody who has been assaulted, but who is mistaken as to the person who's assaulted them. So if you're under investigation, the person making the complaint to the police may well have been assaulted, a sexual assault may well have taken place, but that person is mistaken about who has assaulted them. Now remember, this is historic. We'll talk about historic cases in particular when there may be many years that have gone by, and I'll touch on this a little bit more further on. The third type of person is somebody who has not been assaulted at all and is simply making up the allegation. You might think, well, why would somebody make up an allegation? People think, well, if somebody goes to the police to make a complaint, clearly they must have been assaulted. And the police these days will often the starting point will be that person makes the complaint, we assume that person has genuinely been assaulted, and they investigate. But if I just go off on a slight tangent, probably around about 25, 30 years ago now, I used to lecture in law, and I used to do fairly regular presentations to groups of people and professionals concerning evidence in the criminal justice system and the problems with identification or false identification. And when I did the presentations, I nearly always combined that, and the speakers that I would have with me would be psychiatrists, psychologists, psychoanalysts, because the evidence that comes from complainants can be flawed. There can be serious problems with that evidence. And going back many, many years, there's so many studies from around the world of why people can either be mistaken as to the identification of the person who's alleged to have assaulted them, or simply could be making it up. You may well have heard recent stories in the media of people who have actually been prosecuted for making false allegations against other people. So we know that people will make false allegations, but we also know from studies, well-researched studies going back many years, of people who have been assaulted but who make a mistake as to the identity of the person that's assaulted them. And this can be false memories, it can be all sorts of issues that arise in that person's life. That person may genuinely believe that they have been assaulted by you, for example, but they're completely wrong. But they genuinely believe that. And this is a particular problem, and there may be a real difficulty here in getting over and in effect establishing your innocence. Because from the police point of view, that witness is extremely strong. That witness is very credible because they are so passionate in their belief, so believable that they have in fact been assaulted by you. So the police when they're looking and when they're weighing up the evidence, think, wow, this person is really forceful in their view. We really do believe that this person has been assaulted. So that could be a real difficulty. So looking at somebody's background, looking at their mental state and the mental health is really important. That takes us on to a slightly different aspect when we're looking at evidence, because if you are under investigation, then really your solicitor, your team, your legal team, should start to look at the background of the complainant. Because in my experience, many people who make allegations of sexual assaults, whether they are true or unfounded, whether they've got the right person or the wrong person, many of those complainants have mental health issues. So looking at the mental health of the complainant can be an important factor in any defence. Now, it's not to say that every aspect of somebody's mental health can be used in a trial, but it may well be relevant to a case. But if you don't investigate it to start with, then you'll never know. But the mental health of somebody may well be a factor as to why they are making something up, i.e. attention-seeking disorder, or whether they're mistaken as to the identity of the person, even if they have been actually assaulted. Again, I touched on earlier, that's really relevant more with, I think, historic cases, because if somebody walks into a police station and says, I was assaulted yesterday, there's probably less chance of having a mistake as to the identity of the person that's assaulted them. Whereas if it's something that's 30 years ago, 10 years ago, 20 years ago, then over time, memory can really affect somebody in strange ways. And somebody can over time believe something has happened that hasn't happened, or they've been assaulted by a different person than the person that has actually assaulted them. So taking advice, working with professionals is absolutely vital. With your individual case, if you're watching this, if you've been accused, then please don't just wait for the police to conclude their investigation before you do anything. I'm often contacted by people who have maybe had a duty solicitor represent them at the police station, and the advice often is, well, get in touch with us again if you're charged. And then it goes quiet for several months. And sometimes people telephone me and say, well, this happened 3, 4, 5 months ago. I've just not heard anything. I don't know what's happening. I can't live my life like this. It's the anxiety is killing them. And it's very, very frustrating for them, but also from my point of view, when I think, well, we've actually lost 3 or 4 or 5 months of time when we could have been working proactively on this problem and deal with it, deal with the police, work with the police to try to get them to take no further action. Because what we're able to do during that period of time is start to look at the background of the complainant, start to work with the police, start to look at the prosecution service, the evidence, ask the prosecution to investigate certain issues. For example, if we've got concerns about the complainant's background. Often there is issues related to their social media, what they put on text messages, Facebook accounts, social media, that may need more investigation work. Recent cases have been prosecutions have collapsed because the prosecution haven't disclosed to the defence certain data in telephone records of complainants. So you may want access to those telephone records or data records, computer records belonging to the complainant. Now, all this can be worked on during the investigation side. It's also important that with any serious offences and historic offences, the police will almost always refer that case to the Crown Prosecution Service for an advice prior to any charging decision. So the police themselves won't decide you're going to be charged with rape or sexual assault, whatever it might be, making that decision themselves. They will always refer it to the Crown Prosecution Reviewing Team, and a reviewing lawyer at the Prosecution Service will look at the evidence as presented by the police and then decide whether you should be charged. And if you're going to be charged, what offence or offences you should be charged with. At that stage, of course, we can work with the police prior to charging decision. We can try to influence the police to take no further action. If it goes to the prosecution service for an advice, we can liaise with the prosecution service to try to persuade them not to charge, or if they are going to charge, to try and persuade a lesser charge, a less serious charge. Now, that's not saying you have to accept that charge, but but it's better to be charged with a lesser offence than a more serious offence. Of course, you can still defend it, but it takes off some of the pressure, and equally may affect which court deals with it, or the seriousness of it, the length of sentence, the length of prison sentence, or whether you go to prison, etc. So all of those factors need to be looked at and dealt with whilst the police are investigating your case. Don't just wait until a charging decision is made, because the charging decision is based on the information given to the prosecution by the police, not necessarily information given by you or your lawyer to the Crown Prosecution Service. And equally, if you've not got your own lawyer, or your lawyer is not being proactive and not doing this, then the prosecution may not have the information that you would want them to have, which backs up your case. So if there is anything further, any other questions that you want to go over, then please contact me. Initial consultation is always free of charge anyway, and if we do act for you, particularly during the investigation side, then most of that work we do on a fixed fee basis, because there is no legal aid available for that type of work. So we can undertake the work, we can represent you, but it would be usually on a fixed fee basis, try and keep the costs as low as we can for you. But that's something we'll talk through, go over everything with you if you get in touch. Well, thanks very much for watching. Goodbye.